Check.
Track baby, try another one.
Duse M,
Jump on it. Jump on it. Ride it like
Jump on, ride it like Jackie. The hell smoking that loud, lace the yak with mouth. Make your mama proud, popping it like shot. Turn up, it's a gangster party.
PT, ain't never popped a Mari, but if I ever catch Mac, I'ma pop a Holly. I don't even rob a cop the Harley. Blowing so much green, I shame Marley. Yeah, I push the line to its full limit. Hit the hole like 22, boy, I'm a young Emmett. Nothing go like snow, now that's a cold image. Still whistling, sending, knocking them white women. Only reason I do it to avenge image. To the day they go before and they box me out. Knowing me, it don't matter, I simply change my route. On my hobby.
Where's. Welcome to the Damu Kiwe Conversations, home of the West Coast, the voice of the culture. Duse M's the dime, and we got the content. So we're going to get to this real quick. I'm going to break down the paperwork, and then we're going to watch Byron Blake video. Salute to Byron Blake. We could bump heads. I got no problems with the brother or no other brothers, period. You understand what I'm saying? But he was misinterpreted the difference between an overt act and an actual charge, substantial charge under federal sentencing guidelines and federal law. You know what I'm saying? And he came with some content that we're gonna get into that first, and then I'll read. I'm gonna read the Big U paperwork. Then I'm gonna do another video and right after, and I'm gonna read the government's paperwork, objection to Big U's position. And then tonight on the live, we're gonna get into both, and I'll break them both down. Let's go. Y'all be sure to hit that like button, you know what I'm saying? And share the Cash App is on the thing. Go Lakers! Lake Show playoffs here. Today we got the play-in, and then the playoffs will be coming. The favorite time of the year. Let's get to the content though.
So, Big U filed a motion to exclude prior act evidence. In this motion, he challenged a lot of different things, but today we're going to be focusing on the overt acts, because there are certain overt acts that Big U felt like the government included in his indictment just as filler, kind of like fluff, you know. Now, specifically, Big U would accuse the government of including a catch-all category in his indictment. This catch-all fear and control over community and victims category. He says that it relies on overt acts 106, 110, 111, and 145 through 170 generally, you know, and he would list these overt acts and basically say that the omnibus category is too vague to permit meaningful notice and too broad to allow fair litigation. The government.
Now, I agree with Big U's point. The federal sentencing, the federal law permits too broad of an interpretation of material evidence when you're talking about conspiracy and RICO cases. There's no ifs, ands, or buts about that. It's a railroad. And you get overzealous prosecutors who want to put any and everything that can possibly, not that it is actually interpreted as material evidence, but it shows a pattern, right? And they'll throw it in there. Some of the most salacious things that have nothing to do with the case. Prejudicial evidence. Prejudicial facts that even though not directly related to the alleged charges that he's substantially being charged with, but someone could hear he beat a white broad, which has nothing to do with this, but because he said he want to beat up Whack 100, right? They say, well, this shows that he likes to beat up people. And then somebody be like, but he beating, it's a difference between beating on a white, but some people don't see it like that. Oh, he's a piece, he deserves to do this. Not saying Big U did beat on a white broad. I'm just showing how the total contrast of this hypothetical with the case at hand, and yet the government would still argue that it shows a pattern, which opens the floodgates to prejudicial materials as material evidence before a jury. Let's go.
Cannot admit a sweeping block of alleged overt acts generally as proof of fear, power, or control without identifying the specific evidence, witness, exhibit, and non-propensity purpose for each item. Basically, he's saying that, you know, they are saying that they are trying to prove that he has established fear and control over the community and victims to, you know, explain why people haven't spoken out or why people were going along with the extortion. And he's saying that a lot of this stuff that, you know, y'all have put together doesn't even, you know, say anything. It's just a big group of stuff that doesn't even connect to the actual charges. He cites Rule 404B requiring a disciplined item-by-item propensity-free chain of reasoning, not a thematic narrative untethered to particular proof. Basically saying, hey, if y'all gonna have this stuff mentioned in my overt acts, then there needs to be some particular proof that, you know, ties me to these overt acts. Otherwise, y'all just throwing a bunch of allegations out there.
You don't know what
I agree. I totally agree with Big U's argument as articulated by one Byron Blake. Way to make sure you get that up out there like that.
Is overt act number 150.
So this overt act number 155, this is what he's showing. It says on December 30th, 2022, on an intercepted call, defendant Henley said that when defendant Henley catches Whack 100, I'm going to break his jaw. Defense response: this is a private statement of frustration, not a threat communicated to Whack 100. There is no evidence Whack 100 ever heard this statement, was placed in fear, or was harmed. The government has not charged any assault on Whack 100, right? Let's go.
5, which alleges that on December 30th, 2022, on an intercepted call, defendant Henley said that when defendant Henley catches Whack 100, I'ma break his jaw. The defense response to this is a private statement of frustration, not a threat communicated to Whack 100. There's no evidence that Whack 100 ever heard this statement, was placed in fear, or harmed. The government has not charged any assault on Whack 100. He would also include overt act number 164, which alleged that on January 12, 2023, on an intercepted call, defendant Henley said he wanted to beat the out of Whack 100.
Now, let me clear this up and clarify this before we go. Because he misunderstood the overt acts as it pertains to the arguments about what's going to be admissible, what's not going to be admissible. And in this motion, that does not lead me to believe or to change my position that Whack 100 was a third-party cooperative, that Whack 100 facilitated open source intelligence just chat GPT, open source intelligence, right? That would be used, and you're going to see in the paperwork that they are actually arguing to use Whack 100's interview that he pushed for, that he facilitated on No Jumper with Loose Cannon. So I do believe that Whack 100 is a cooperative and working for the means through Dale Morrison, through Loose Cannon, through Molly Mall, and others, and utilizing his position in other platforms, DJ Academics and Vlad, to publicly attack him and antagonize him as an agent provocateur. Let's get to it.
The defense response to this is the government has not identified what action, if any, followed because none did. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. In support of this, Big U would argue that the government may rely on the proposition that in conspiracy cases, it may prove the full scope of the conspiracy. That proposition, however, does not mean every uncharged act connected in some way to an alleged conspiracy or enterprise is automatically inextricably intertwined.
So basically, everything has a statute of limitation, but that's not what the sister United States attorney is arguing, and we're going to get into that also, right? There has to be some kind of guardrails from allowing anything that the government argues as material evidence, which would prejudice and prevent Big U from getting a fair trial. Let's go.
Basically saying that every single thing that we done, all of this stuff that we not even charged with, is not automatically a part of the conspiracy or, you know, an extension of the conspiracy because y'all alleged that a conspiracy was going on at the same time that this was going on. Critically, even in the RICO context, the government must make an affirmative showing how proof of each incident it seeks to admit constitutes proof of the scope of a charged conspiracy to avoid a Rule 404B analysis. So when you talking RICO cases, to avoid this 404B scrutiny, you have to show how all of these affirmative acts constitute proof of what you are charging us with. You know, if you got a overt act saying, you know, I threatened to break Whack 100's jaw, then you need to have a thoroughly presented breakdown that shows how this is proof of what I'm being charged with. Where the government seeks to introduce uncharged acts that are not alleged in the indictment as predicate racketeering acts or acts in furtherance of the conspiracy and fails to provide 404B notice, the court should exclude the evidence. So he's saying, hey, if these acts are not, if we not charged with this and they not saying that this was done in furtherance of the conspiracy or that it's not an actual racketeering act, then y'all should not allow this in. And in closing on this paragraph, he said,
and I believe that that's, hold on. Yeah, I had to go get the dog, but no, I do agree. But this is something that you guys got to be able to understand and differentiate. In a standard conspiracy, evidence is generally limited to the specific agreement and the overt acts performed to achieve his goal. While RICO's, CCEs, continual criminal enterprises, and traditional conspiracy cases all follow the standard federal rules of criminal procedure, RICO and CCE cases involve specific procedural and evidentiary superpowers that aren't typically available or used in mere conspiracy cases. So this is where dumb truck attorneys, like the ones representing Big U, they up against it. So let's start from there. They're up against it, but this is where they fall short. But at the same time, them raising it preserves appeal rights, and also it makes the judge, it forces the judge to ensure that he has a fair trial, and makes him put some guardrails to protect his constitutional rights to fair trial. But let's get back to the video, and then I'm gonna break down the Big U motion.
Is that where uncharged acts are sufficiently disjointed from the charged pattern of racketeering activity, they cannot be deemed inextricably intertwined and must be subjected to the strictures of Rule 404B. Furthermore, the use of uncharged acts to prove a RICO conspiracy raises acute jury instruction and jury unanimity issues, making it hard for the jury to be unanimous. And as the jury may properly rely on non-predicate overt acts to reach a verdict. In other words, when you're bringing in a bunch of stuff that we haven't been charged with,
most people think that you need
Damu
$200,000 and 2 years of business
conversation. Let's bang that like button. Hold on. Investment banking. I'm going to show you better. Hold on. Why back by hundreds of reviews, sites like Google, Trustpilot, Yep, built you a career. Real experience. Man, I'm thinking that was something about venture capitalists. Let's go.
Fuse the jury and have them relying on something that we haven't been charged with as just an overt act. And they may end up finding us guilty on that. Now, the government would respond to Big U, and they would say that the fear and control category encompasses charged overt acts that are direct evidence. They would go on to say the defendant's motion challenges dozens of overt acts alleged in the first superseding indictment, styled as Rule 404B concerns. That framing is backwards. The government is entitled to prove the overt acts charged in its own indictment. These are not uncharged other acts. They are part of the charged RICO conspiracy, and proof of charged overt acts requires no 404B justification. Now, the reason I was emphasizing uncharged in the last stuff that I was reading from Big U is because I was seeing that they were locked in on that. He kept saying, y'all saying I threatened WAC 100. I'm not charged with that. Y'all saying that I said I wanted to beat up WAC 100. I'm not charged with that. The government is now coming back and saying that, yes, you are. The fear and control category that Big U is talking about encompasses charged overt acts that are direct evidence. Again, it says these are not uncharged other acts. They are part of the RICO conspiracy, and proof of charged overt acts requires no 404B justification. So, long story short, Big U is charged with assaulting WAC 100. It says it right here in the paperwork. He mentioned WAC 100.
No, if it was charged, you'll see it at the top right of the indictment, right? Those are the charges. The overt acts are being argued because it's a RICO case. So if they could first prove, remember, Puffy had a RICO case. If they could first establish a criminal enterprise for RICO and then prove overt acts in furtherance of this enterprise, each one of these, he could be held accountable or liable for the actual crime of, if it's a murder, 25 years to life. I believe that's what it is in the feds also. Maybe it's 360 months to life, right? If you're going by the United States sentencing guideline. Or if it's a gun, up to 5 years or whatever, right? So this is where I think Byron Blake, as great as he is, felt a little short. Listen, bro, he kills it. We human. You guys can't come down on him because he misinterpreted something. He's not a lawyer, but he's damn close to it in understanding it. So we don't tear down our people, especially when they're great. We build them up. Constructive criticism. You don't attack to tear down. You address each one, teach one. Let's go.
Specifically, and this has been a topic for quite some time. WAC has always been saying, I'm not in the paperwork, I'm not in the paperwork. And people have been debating over whether or not WAC was actually involved in this investigation in the eventual charging and incarceration of Big U. Now, here we have it. Right here, the government is saying that Big U is charged. These overt acts are not just things that were mentioned in the paperwork for exercise. You know, these are things that Big U is actually charged with, you know. And the reason why I find that funny is because one of the overt acts says that Big U made a statement saying that he was bigger than Nipsey Hussle. And I'm still confused on how that constitutes a federal crime. But like I said, the government is now saying that Big U is charged with assault on WAC 100. He's also charged with making threats to WAC 100. I'm interested to see how this is going to play out because WAC has been trying very hard to keep his name from being attached to this in the witness aspect. But when you look at things like this, the defendant should remain detained for the safety of the community, the victims and witnesses in this case. In defendant's own words, if I would have had a problem with any man, the issue would have been resolved and he wouldn't be here or I wouldn't be here. And for the hope of some semblance of justice for the families of his victims. Indeed, with seemingly just hours of notice of his pending arrest, defendant has already destroyed valuable evidence, attempted to paint a false narrative of his criminality in the public, and publicly condemned his enemies by name. He cannot be allowed to continue on this obstructive path. They would also state that further, the defendant's release would pose a serious risk to individuals whom have assisted the government in this case, as well as witnesses and victims who have so far refused to cooperate or provide statements because of what they know. As defendant made clear in an intercepted call on January 5th, 2023, being a rat means you are done. Indeed, trying to intimidate and dissuade anyone from cooperating with law enforcement or otherwise reporting information about defendant before turning himself in, defendant posted an Instagram video naming his co-defendants and known opponents, instructing the public to not associate with them and claiming if they did, they were not black.
Most people have no
Damu Kiwe Conversations. Hey, listen, man, y'all go ahead and bang that like button. Let's go.
What they basically doing here is this is two separate instances where the government was arguing that Big U should not be allowed to have bail. He should not be released. And in each one of those instances, they bring up the video that he made before he turned himself in. Now, if you're not familiar with this video, take a look.
So this is gonna probably be my last video. I'm gonna go turn myself in to see what's going on. They talking about I'm a fugitive. So they just raided all my houses 600 was actually with the police when they raided my house. And he's actually got video and footage of it, so y'all know what y'all dealing with. And I just want to say this to y'all. When they raided my houses and my property, they was asking about whack, loose cannon, 600, and this internet stuff. All of y'all filed. All y'all who be sending shit around the internet, all y'all who be promoting and listening to what they're saying, all y'all giving these likes and hidden likes, all y'all supporting this. All y'all guilty of this shit. If you had something against a black man, you should handle it with a black man in the streets. Wack said 100 times he was gonna take my contracts. He working with the FBI.
When you take that video and couple it with the fact that the government is specifically referencing this Instagram live and saying that, you know, this guy is attempting to intimidate witnesses and victims and possibly deter other witnesses and victims, and they cite that he called out known opponents, it's pretty obvious what's going on here. I mean, Big U is saying, hey, y'all bringing up WAC 100 in these uncharged acts and trying to use this stuff against me. And these aren't even crimes. Y'all haven't presented me no evidence of me doing anything to WAC or saying that WAC was inferior or any type of proof that I did this. And the government is responding saying those are not uncharged acts. Those are charged acts, and the proof will be offered at trial. So we can expect to see at some point during Big U's trial, the government put on a presentation of a crime that Big U allegedly did against WAC 100. And I'm assuming that we are going to see WAC 100 testify in some form. And WAC knows that the time is coming, which is why I believe he made this video.
I always like to come to y'all first about anything I'm doing. I got a tough decision to make. Big U, when he turned himself in, made accusations that WAC 100 and 600, he mentioned loose cannon, which he may very well be, but WAC 100 and 600 was working with the feds to take him down. He said this to the world. My legal team, when it comes to my overall businesses and things that I do, they have some say-so in this matter. So I've been fighting them on what I didn't want to do, which is file anything against Big U for defamation and slander, as I did with World Star and LA Media, and I won that case, and I got paid. So anybody that talks to this man, communicates with this man, I'm trying my best to keep my legal team from doing what they feel they're obligated to do.
To me, this was clearly WAC trying to intimidate people into not running stories about him snitching on Big U or being involved with Big U's case in any kind of way, basically trying to put the narrative out there that this stuff is false. But as we see here, Big U is saying, hey, these are uncharged acts that y'all trying to put on my indictment. And the government is saying, no, these are not uncharged acts. These are part of the conspiracy and they are charges. So WAC obviously just talking because you're not going to get to sue. You can't sue somebody for telling the truth. You know, he's charged, bro. And it's related to you now. I'm interested to see how you will explain him being charged with a crime related to an offense with you that you claim you did not cooperate in.
Why is you in his paperwork
if they had no
anyway?
Information that he actually talked to you or threatened you or had an encounter with you, that they will be going forward with this. So obviously they got some information.
Man, why are you in Big U paperwork anyway? Y'all ain't got past that. Let's finish this so I can read this paperwork.
Information that this situation actually happened. Could it be?
Call third now. Now I'm about to expose something nobody ever knew.
Oh, shit.
So here it goes, right?
Ground zero,
I'm here. All of this is a parking lot, right? I'm here. They walk down. They walk right past my car. They didn't even see me. When I seen them get here, I jumped out. Y'all looking for me? Right?
Shit.
They stopped. They back was to me. Y'all, I had everything I had, I could have dealt with everything in front of me. Now, what they didn't know is I'm talking to my team. Big U is here. Now watch this. Look, watch this. Big U is here. I'm here out the car. Third, who was here, and here?
You taking notes?
Hold on. Third, who in that parking lot when I'm confronting these 20 Crips was 20 to 30 feet in every direction and they didn't know it? All my homies was behind them.
That's new information.
Listen.
That's new information, man.
So listen, check this out. So when I'm letting you know, there's no need to beg nothing. What did I tell that fool?
Let's do it.
My home, they still don't know to this day that all my homies was positioned 11 o'clock, 2 o'clock, 6 o'clock. They didn't even see them. I'm talking to my homies in code, letting them know which way I'm gonna push them. I said, nigga, ain't number 20 of y'all. I'm going to down 3 of y'all. I just told him I'm going to get off in 3s. Right? At that point, he knows if he's getting off in 3s when he go to 2s, he's running out. These dudes right now to this day had no idea that they was ambushed.
Yeah, man. I don't know, man. I really don't know, man. But what I do know is the time is soon approaching for us to see.
So we that's enough. We got one more video. We're gonna get into Imam. See, practical, you can understand in theory how to build a space shuttle to put someone on the moon, right? How to build the rocket scientists. But until you actually build it, you haven't stumbled across the pain, right? You haven't stumbled across complications that come with that. You know what I'm saying? You don't know the exact diameters necessary until you've done it. And that's what I told Byron Blake before when he jumped out there talking about Sue Surf was the reason Big U was in jail. I agree to disagree with him on that. You know what I'm saying? On Valentine's Day, he kept texting me, arguing about it. On Valentine's Day. You know what I'm saying? Hold on. This is the beautiful Maria. We're going to pause this. Hold on. Listen, man, I don't care how much I'm supposed to have love for y'all. When Maria called, y'all secondary. You understand what I'm saying? We got that big head baby on the way. You know what I'm saying? New addition to the family. You know what I'm saying? Yeah, she's 6 months right now. 6 months. And I'm loving every minute of it. So I think this is the right one. I'm praying this is the right one. No, this is the government's opposition. So we're going to stop sharing that. And we're going to stop sharing that. And we're going to go to Big U's in order. Big U's motion, and then Big U's motion is 34 pages. So let's get off of defendant's motion to exclude prior act evidence, right? Where y'all at? Can y'all see this? Yeah, y'all can see it. So good. And then I'll do a breakdown. Then I'll get into what's the name. So this will be the content for y'all today. Tomorrow, y'all get the governments and the breakdown. Then I'll break them both down in comparison. The hearing time, April 24th, 2026. So they got a hearing coming up April 24th at 1:30 p.m. And I'm going to try to make sure I get some people to go get the content. You know what I'm saying? So defendant Henley, through his attorneys, Craig Harbaugh and Peter Johnson, Sylvester Robinson by and through his counsel. All right, so that's just the certification. And then here it goes. Introduction, legal standard, requirements of federal rules, evidence, 404B. This is what it's all about. What is going to be classified as admissible under the 404B federal rules of evidence. The government must satisfy the strict notice and admissibility requirements. The Rule 403 compels exclusion where the probative value is substantially outweighed by unfair prejudice. 3, the argument the court must exclude several general categories of character evidence that the government may seek to introduce at trial. And then B, the court shall also exclude the 12 categories of evidence, section 1 to 12 below, classified in the government's Rule 404B evidence, right? So the June 15th arrest of defendant Robinson and the ghost gun found in Robinson's vehicle, exhibit D1 to D3. Recorded conversations to which Mr. Henley allegedly discussed the enterprise's use of rolling 16 and 156. That's exhibit E1 to E7. 6, the Nipsey Hussle management dispute. The alleged diss song that claimed that Nipsey had to be disciplined, and the assertion that the dispute with RW unfolded, exhibit F1 through F39. 7, evidence that Celebrity Socks received $6,000 in SBA funds despite allegedly having no income. I don't know if Celebrity Socks didn't have no income. I think Big U might have sent me a couple $100 through Celebrity Socks, which was his original right? Intercepted calls. Maybe I'm wrong. Maybe he has multiple companies. Intercepted calls and surveillance concerning alleged efforts by Mr. Henley and defendant Martin to use violence or threats to recover recording equipment belonging to Lil Wayne and NBA to H16. Is that H? Yeah, to H16. So they're talking about Big U alleged efforts and Martin to use violence or threats to recover recording equipment belonging to Lil Wayne and NBA Youngboy. So he's advocating, it sounds like somebody stole some equipment or something, and he's advocating, man, you ain't finna do our people like that. You know what I'm saying? And they trying to bring that in to prejudice his defense. So the juror be contemplating these facts, sensationalized by these facts, and distracted from what the government haven't produced, right? Putting paint where it ain't. Witnesses to anticipated testimony concerning A, his 2016 or 2017 donation for helmets. B, so witness 2's anticipated testimony concerning A, his for helmets, B, the statement regarding Nipsey Hussle, and C, witness 2 allowing Mr. Henley's artist to record for free because he felt he could not say no. So witness 2, if to take an educated guess, is the rat Molly Mo, Whack 100's bestie, the one he put on the phone with Adam 16. 10, donor ones. Anticipated testimony concerning A, his donation as an alleged donor victim, B, an attempt to clear a gambling debt, and C, the allegation that Mr. Henley recovered fraudulent gambling winnings for NBA players. Exhibit J1. So 11, additional sex-related intercepted communications, including November 28, 2022 and January 7th and 19th, 2023 calls, and alleged January 7th, 2023 payment discussion, and the February 8th, 2023 massage company with Happy Endings call. Going to indict this man for this. What happened to the owner of the Patriots, Robert Kraft? Oh, I see what's going on. You know what I'm saying? y'all definitely want the leaders from within our community, those with structures, up out of there. But y'all leave those, yeah, by providing notice of 12 categories of textbook character evidence to an already bloated 43-count first superseding indictment, the FSI. The government seeks to trigger outrage, facts, confusion, facts, and a series of mini trials that will take weeks to defend, serving only to exhaust, distract, and prejudice the jury. Ain't that what I said? Its notice does not identify a narrow set of genuinely probative non-propensity evidence. Instead, it attempts to convert a sprawling collection of alleged other facts, rumors, public boasts, coded statements, celebrity disputes, sexual commentary, unrelated financial conduct, and supposed flight evidence into admissible proof by repeatedly invoking modus operandi, enterprise evidence, or intrinsic evidence. That is not enough. This court should exclude this prejudicial noise and require the government to try its case on the facts, not on character assassination. Facts. Hey, listen, Big U, I don't agree with. I think they left a lot to be done. I'm not better than them. Don't know the law better than them, but I have studied the facts, had the time to study the facts closely. And there's a lot of things I haven't seen, but a lot of stuff is foul. So legal standard. Requirements of federal rules of evidence 404B. I'm going to read this because just like me, none of you guys are lawyers, so we're laymen's. And so I can't assume that y'all understand the law. For y'all to get the proper context, we got to read it. I got to read it. The government bears the affirmative burden of proving all four elements of the Rule 404B test before any other acts evidence may be admitted. 1, the evidence tends to prove a material point. 2, the other act is not too remote in time. 3, the evidence is sufficient to support a finding that the defendant committed the other act. And 4, the act is similar to the offense charge. They cite U.S. versus Cox, a 9th Circuit case, which governs the Central District of California where Big U is being held and charged. B, the government must satisfy the strict notice and admissibility requirements of Rule 404B. Rule 404B 2020 amendment heightened the government's notice obligations, requiring the prosecutor to articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. Federal Rules of Evidence 404B3B. The government may not simply recite a list of Rule 404B purposes and be done. It must articulate precisely the hypothesis by which one or more consequential facts can be inferred from this evidence. They cite United States versus Marmonesh, another 9th Circuit case out 1982. Likewise, the government may not simply conjure up a proper purpose. It must also establish a chain of inferences, no link of which is based on a propensity inference. They cite U.S. versus Smith, Third Circuit, 2013. This logical connection must be supported by some propensity, free chain of reasoning, and they cite U.S. versus Rodriguez, Ninth Circuit, 2018. Quoting U.S. versus Gomez out the Seventh Circuit, 2014. C, the inextricably intertwined doctrine cannot be used to circumvent Rule 44B. So, off the top, Big U's attorneys is saying, y'all, the U.S. attorney is trying to say it's inextricably intertwined, this hearsay evidence, these wiretaps evidence is inextricably intertwined doctrine, and they're utilizing that to rush evidence through the doors in mass drones to be able to do, say, prejudice and contaminate the jury pool and the jury's mind with a lot of other distracting stuff that doesn't necessarily pertain to the case. The inextricably intertwined doctrine is a narrow exception that cannot be used to bypass the protections of Rule 404B. Many circuit courts reject the doctrine entirely because it has outlived its usefulness and become overused, vague, and quite unhelpful, citing U.S. versus Gorman at 7th Circuit 2010. As the Third Circuit, so 7th Circuit, 3rd Circuit, has noted, the inextricably intertwined test is vague, overbroad, and prone to abuse. And we cannot ignore the danger it poses to the vitality of Rule 404B. So you have some appellate courts already making mention of how it's broad. You know what I'm saying? It's vague. It's overbroad and it's vague, right? It's prone to abuse because it's going to allow evidence that prejudices the defendant and now his constitutional right to a fair trial on the charges that he's set with aren't the issue. He's being denied that. He'll be fighting multiple charges that aren't even charged. So, the Ninth Circuit recognizes only two narrow categories of evidence that may be deemed inextricably intertwined. When the act constitutes a part of the transaction that serves as the basis for the criminal charge, or is necessary to permit the prosecutor to offer a coherent and comprehensible story regarding the commission of the crime. U.S. versus Loftus, 9th Circuit, 2016, and U.S. versus Cervantes, right? Another 2016 case. 1, conspiracy cases do not exempt every uncharged act from Rule 404B. The government may rely on the proposition that in conspiracy cases, it may prove the full scope of the conspiracy. United States versus Risk, 9th Circuit, 2011, and U.S. versus Montgomery, 2004, the 9th Circuit. That proposition, however, does not mean every uncharged act connected in some way to an alleged conspiracy or enterprise is automatically inextricably intertwined. The 9th Circuit makes clear that the doctrine remains narrow. Visaria Martinez. Critically, even in the RICO context, the government must make an affirmative. Now you notice they differentiate conspiracy and RICO because RICO gives the U.S. attorney superpowers. These are the type of powers that you're given to overzealous prosecutors. Critically, even in a RICO context, the government must make an affirmative showing how proof of each incident it seeks to admit constitutes proof of the scope of a charged conspiracy to avoid a Rule 404B analysis. Again, they cite Cervantes, where the government seeks to introduce uncharged acts that are not alleged in the indictment as predicate racketeering acts or acts in furtherance of the conspiracy and fails to provide Rule 404B notice, the court should exclude the evidence. Bass, Supra at 11. Where uncharged acts are sufficiently disjointed from the charged pattern of racketeering activity, they cannot be deemed inextricably intertwined and must be subjected to the strictures of Rule 404B, citing Cervantes. Furthermore, the use of uncharged acts to prove a RICO conspiracy raises acute jury instructions and jury unanimity issues, as the jury may improperly rely on non-predicate overt acts to reach a verdict. ID at 1233 discussing U.S. versus Frege. D. Rule 403 compels exclusion where the probative value is substantially outweighed by unfair prejudice. There has to be a scale of justice, right? Even where 404B evidence falls within a permitted purpose, it should be excluded under Rule 403, where if the court finds that its probative value is substantially outweighed by a danger of unfair prejudice. U.S. versus Preston, 9th Circuit, 2017. Character evidence is said to weigh too much with the jury and to so over persuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge, meaning the charge that he was charged with at this time. They were convicted him because of his past or his reputation, his character, right? The 9th Circuit has established that a court does not properly exercise its balancing discretion under Rule 403, where it fails to place on the scales and personally examine and evaluate all that it must weigh. U.S. versus Curtin, 9th Circuit, 2007. The court is required to have read every word of the evidence, because one cannot evaluate a Rule 403 context what one has not seen or read. This every word requirement is applied consistently across all categories of evidence. U.S. versus Lay, so that's 9th Circuit, which says, assuming without deciding that the district court abuses discretion by failing to preview all of the prescription data before granting the government's motion in limine. U.S. versus Waters, another 9th Circuit, determining that it is the court's responsibility to read every page of the articles. 9th Circuit, 2015, reversing where the court failed to review prior interviews. So they're basically showing the judge, look, you have to review this and read every word in every line before you make a decision on what's going to be admissible. And they need to be seen and viewed in their own context individually, because some you might find are pertinent and material, others you might find otherwise. I'm getting a call from the beautiful Maria. Hold on. Hey, well, you know that's what them hormones do when they pregnant. But y'all got to bear with us, man. We gonna make all this work. So third, the argument, right? The court must exclude several general categories of character evidence that the government may seek to introduce at trial. The first superseding indictment, FSI, while expansive in its RICO allegations, threatens to devolve into a circus of other acts that are not predicate acts of the RICO. Oh, I'm on the wrong page, bro. My bad, man. Let me go ahead. No, I'm on the right page, right? So I'm apologies, man. You know what I'm saying? Apologies, man. All right, charged in any substantial count and serve only to prejudice the jury. Pursuant to federal rules of evidence 404B and 403, Mr. Henley moves to exclude several categories of highly prejudicial evidence, including 1. Sensationalized references to celebrities and deceased public figures. Smart. 2. Inflammatory social media posts and media commentary from podcasts or documentaries that reflect Mr. Henley's public persona rather than the specific criminal acts charged. Smart. Irrelevant evidence of uncharged financial transactions, gambling activities, and unrelated tax issues. Smart. And 4, references to the Rolling 60s neighborhood Crips, where such evidence is purely prejudicial and not strictly necessary to prove an element of the alleged RICO enterprise. Smart. The court should also exclude the 12 categories of evidence, sections 1 to 12 below, identified in the government's Rule 404B notice, as detailed in the sections that follow. Each of the 12 categories fails the Ninth Circuit's 4-part test for admissibility under Rule 404B. 1. It does not prove a material element of the offense. 2. The prior act is too remote in time. 3. The evidence is insufficient to support a finding that the defendant committed the act. And 4. The act is not sufficiently similar to the charged offense, even if the evidence met this criteria. Its probative value is substantially outweighed by the danger of unfair prejudice, confusing the issues, and misleading the jury under Rule 403. 1. Check-in evidence, Exhibit A1 through A8. First, the proffered material is quintessential propensity evidence dressed as branding. The government seeks to transform a phrase, persona, and media presence into proof that Mr. Henley acted in conformity with an alleged extortionate practice. Rule 404B squarely prohibits this reasoning. See Federal Rules of Evidence 404B1. Second, the government's notice is facially deficient. It fails to identify with any specificity the particular clips, recordings, images, or witnesses it intends to introduce. The notice vaguely states that it will offer clips of defendant Henley discussing the check-in. What can happen if you do not check in, including to film crews, what he has done to those who do not check in, and the existence and theme song of the Checking In podcast. Exhibit N. Snoop Dogg made that song. So are you indicting and saying that Snoop Dogg, a veteran hip-hop artist of almost over 30 years, is criminally a conspirator because he made a song about checking in and the dangers to those in the industry who just come around willy-nilly? It's a warning. A warning not of Big U, but of those wolves in LA. It's nasty work, bro. This sweeping description is inadequate to permit either the defense or the court to conduct the required Rule 404B and Rule 403 analysis. Exclusion is warranted on this basis alone. Third, the limited material the defense can identify, particularly a video apparently referencing film crews, is remote in time, lacks foundation, and does not establish any extortionate conduct. Exhibit A7. Undersigned counsel is informed and believes that this content dates to approximately 2017, outside the time frame of the overt acts alleged in the first superseding indictment. Such unsubstantiated, temporarily remote material cannot satisfy Rule 404B's threshold requirements and carries a substantial risk of misleading the jury. I agree. But I'm telling y'all, those superpowers from the RICO, it'd be so hard. It'd be such a fix. But this is definitely a great move by Big U's attorneys, preserving these issues for a possible appeal, right? In case they do too much, and that gives them opportunity to get back on the appeal. But it also forces the judge, if he is just, to weigh each evidence on its own before making it admissible, going through each one, which is going to take time. And it might also be a tactic to get what the attorneys have been wanting. Big U haven't want to waive no more time, but to force the judge to go through all of this and have to give Big U attorneys more time to prepare for trial, right? Okay. Fourth, the government's theory improperly attempts to retrofit a broad check-in narrative onto charges that are pleaded in materially different terms. Although the indictment references checking in as a purported mechanism, none of the 184 overt acts alleges a check-in. See FSI overt acts 1 through 184. This is a strong point, bro. Not one of 184 overt acts alleges a check-in. But they want to introduce this prejudicial evidence because it's intrinsically entwined to the RICO charge. His modus operandi. If Big U judge finds that it is, that could be prejudicial because it's so far outside the spectrum of the overt acts and the substantial crime. In fact, Big U has never been charged with extortion on a check-in. So, instead, the government's own pleading uses terms such as tax, rent, donation, and payment. The proffered check-in evidence is thus untethered to the specific conduct charged and risk inviting a verdict based on generalized reputation or fear rather than proof of the alleged predicate racketeering acts. Fifth, the proposed introduction of a podcast theme song associated with a well-known artist raises distinct constitutional and evidentiary concerns. Courts have recognized the heightened risk of unfair prejudice when the government seeks to use expressive or artistic content as substantive evidence of criminal conduct. U.S. versus Williams, right? Finally, any marginal probative value of this category of evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, and misleading the jury. Federal Rules of Evidence 403, permitting the government to present generalized rhetoric, media branding, and artistic expression as proof of a pattern of racketeering would shift the trial from adjudicating specific alleged acts to evaluating a persona. Accordingly, all check-in evidence should be excluded. 2, Defendant Williams' public statement. loose the liability cannon, the fake loose cannon, terrain, sweetie. How did all of y'all try to claim that he wasn't snitching or lie snitching when he did that interview on No Jumper? And Whack 100 is the one that orchestrated Loose Cannon to do this third-party cooperation, open source intel on No Jumper. Whack 100 is Big Meats. I think I'm Big Meats. Big Meats. Tekashi 6ix9ine. Gucci Mane. All these niggas Pizzor. Swizzine. So, first statements by Williams are not admissible against Mr. Henley simply because the government says they illuminate enterprise structure. If Williams does not testify, admissions of these statements raises serious hearsay, confrontation clause, and Bruton concerns. Now, this is a major issue, right? So I'm gonna do a video on where the six, matter of fact, I'm gonna try to see if I could do it right now, right? Let me see how long. No, I'll do that on another video. Specifically where the confrontation clause came from and why it's so important, right? If Williams does not testify, admissions of these statements raises serious hearsay confrontation clause because you have to have a right to confront your witnesses. Well, Tremaine is a defendant, and his attorneys might not want him as a defendant to take the stand because it opens him up to all kind of other liability. So strategically, he don't want to take the stand, but Big U has a right to confront all witnesses and statements used and made against him, right? So this is a powerful argument. Salute to Big U's attorneys on this one. Second, if the government invokes Rule 801 D2E, it must first establish with independent evidence that the statements were made during and in furtherance of the charged conspiracy. Third, even apart from hearsay, the label enforcer is unfairly prejudicial and conclusory. Right? I'm Big Useless Enforcer. Who believes that? You know what? I think the jurors should hear that shit so they can know that this nigga full of shit. Fourth, the No Jumper incident risks devolving into a mini trial within a trial concerning an uncharged robbery with powerful spillover prejudice. The court should exclude the category in its entirety. The catch-all fear and control over community and victims category, including reliance on overt acts 107, 110, 111, 145 through 170 generally, exhibits C1 through C28. This omnibus, I guess I pronounced that right, omnibus category is too vague to permit meaningful notice and too broad to allow fair litigation. The government cannot admit a sweeping block of alleged overt acts, generally, as proof of fear, power, and control without identifying the specific evidence, witness, exhibit, and non-propensity purpose for each item. Rule 404B requires a disciplined, item-by-item, propensity-free chain of reasoning, not a thematic narrative untethered to particularized proof. Oh, they shot this thing. They calling it AUSA out on they bullshit. They on bullshit, bro. This is how the niggas get railroaded, bro. This the type of shit that the judge can stick his hand too heavily on the scales of justice and you get railroaded. You know what I'm saying? Man, prayers for Big U, prayers for Big U family. Nonetheless, each of the overt acts cited below and the associated evidence should be excluded from evidence pursuant to Rules 401, 403, and 404B. Overt Act number 106, Exhibit C1 to C2. On February 14, 2023, on an intercepted call as part of the extortion scheme, Defendant Robinson told Defendant Henley that Defendant Robinson told Jew Boy that he owed the Big U enterprise money, that they would allow a payment plan, but if he did not pay, they were going to shut this motherfucker down. Defense's response. First, nothing in the call indicates that the contents of the call relates to extortion, as opposed to a business dispute. Second, the statement, shut this motherfucker down, is ambiguous and is not a threat of violence. That's a hell of an argument. I'ma shut this motherfucker down could be all business. Nigga ain't no more weed dispensary or whatever the business he had with the alleged Jew boy, right? Third, evidence related to Jew boy is not a predicate act, and the government has given no indication that it will call Jew boy as a witness to prove a predicate act or to assert that he was in fact extorted. Oh, you think that the government ain't gonna bring this small hat to come corroborate that? The small hat was already an informant. In fact, the small hat was sentenced to jail and has been out 7 years without ever turning and doing a day in jail. And you mean to tell me that Big U attorneys don't believe that this alleged Jew boy is going to be a witness? I'm not sure about that, but I'll make sure that that research that I got on looking for this alleged Jew boy, that make sure that I get that to Big U's attorney, that information, because that might be an incentive for him to lie, right? Because he's trying to work so he don't have to do a day in jail, the prison sentence that he was sentenced to, right? And so fourth, introduction, I'm starting to see a trend, right? So he's ducking jail time. Ain't no telling what Marley Marl's ducking. You got Dale Morrison, long tail Dale the Rat. He's ducking jail time and another indictment and sentencing in Ohio that he got caught up on. And they're gonna they recruited these guys who were compromised with things that had nothing to do with Big U. And we'll give you this if you say this. We'll take time off your sentence if you testify against Big U. Nasty work, bro. So fourth, introduction of this extraneous and extraneous and out of context call will be a confusing waste of time and result in a mini trial about an act that does not relate to any extortion counts in the FSI. Overt Act number 110, Exhibit C3 to C6. On April 11, 2023, on an intercepted call, Defendant Henley and Blanton discussed an individual whom the Big U enterprise was planning to rob in the near future. Defense response. First, the call and the overt act provide no victim, no location, and no evidence any robbery was ever planned, attempted, or completed. This is vague, conclusory allegation with no corroborated evidence. See, corroboration, whack 100 corroborating. Yeah, you know why he kept gave back the 40, because he was gonna keep 20. right? Those are corroborating evidence. In these type of cases, that's what it requires to get indicted, to get convicted, to even have evidence admissible into court. Wack understands that. And that's why he was on there corroborating modus operandi against Big U. Oh, this is how you do it, right? Second, the alleged plan to rob in the near future does not connect in any way to the Hobbs Act robbery alleged in the FSI. In short, the government cannot sustain a RICO overt act on a conversation with no identified victim, no follow-through, and no specifics. Therefore, the court should exclude the call. Agreed. Overt Act number 111, Exhibit C7 to C11. On April 17th, 2023, on an intercepted call as part of the extortion scheme, defendant Henley, I told y'all when Maria called, y'all got to get put on pause. Pause. So, Overt Act number 111, Exhibit C7 to C11. On April 17th, 2023, on an intercepted call as part of the extortion scheme, defendant Henley directed an individual to deliver a message to another marijuana dispensary owner that defendant Henley said, fuck him, and that he fucked with the wrong guy. What does that got to do? Defense response. First, the government does not explain how the events described in the call are sufficiently similar to the charged conduct necessary to prove a genuinely disputed issue or more probative than prejudicial. Second, the call contains no threat of physical violence, no demand for money, and no identifiable victim. Third, the government is attempting to criminalize profane speech. The statements fuck him and he fucked with the wrong guy is crude language, not a criminal threat. Fourth, without evidence of a prior relationship, a demand, identification of the alleged marijuana dispensary owner, or a follow-up act, this does not constitute extortion or a pattern of racketeering activity. Fifth, introduction of this call is not necessary for a coherent story. Part of the same transaction of extortion offense alleged in the first superseding indictment. Overt Act number 145. In November 2022, defendant Henley arranged for a co-conspirator to collect an illegal debt from a current NBA All-Star player who purportedly owed $3 million to a Big U enterprise associate. Defense response. By mentioning NBA All-Star players gambling, illegal debts, and millions of dollars, the government is attempting to turn the trial into a confusing circus where distractions lead to conviction. Man, that's so fact, especially because the NBA got that other investigation going on right now, right? This is unacceptable, right? This invites propensity reasoning and celebrity-tainted prejudice. It has nothing whatsoever to do with the counts charged. It is not necessary for a coherent story and is not part of the same transaction of extortion or robbery offenses alleged in the superseding indictment. Further, debt collection, even aggressive debt collection, is not per se extortion. Without evidence of threats, force of fear, this allegation is legally insufficient. Unless the government can establish a direct, concrete, non-propensity connection to a charged count, The court should exclude the evidence under Rules 401, 403, and 404B. That's a good question to ask ChatGPT, right? Is debt collection or even aggressive debt collection bear with me because I want to get to this. Per se extortion. So we finna find out this right now. The short answer, no. Debt collection itself, even aggressive collection, is not extortion. But it can become extortion if certain lines are crossed. So this in itself does not mean it was extortion. The government doesn't want to prove or show any evidence that this was per se extortion until trial, to after they prejudice the jurors. This is nasty work. Overt Act number 146, exhibits C12 through C15. In October 2022, defendant Henley took a portion of the debt that current NBA All-Star player owed as a fee for collecting the illegal debt. Defense response, as stated above, introduction of this call and evidence is an unnecessary and prejudicial distraction from the core of the charges in this case. Further, accepting a fee for facilitating a financial transaction is not a crime. Introduction of this evidence by the government will result in a distracting side trial regarding whether the underlying debt collection itself was criminal. For that reason, the court should exclude this call and any evidence related to this transaction from the government's trial presentation. Whoo! Big U lawyer, bing, 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 bing. They're really making the judge think about each one of these BS elements that they're trying to introduce broadly because it's the RICO superpowers and totally violate Big U's constitutionally guaranteed rights to a fair trial. How is it fair if you're trying to convict me on alleged crimes that weren't crimes, that were never proven to be crimes? But you want that introduced to the jury without sanitization. Nasty work, bro. On November 7th, 2022, on an intercepted call after an extortion victim stated that defendant Henley had not fully paid the extortion victim for work on defendant Henley's vehicle. Defendant Henley directed defendant Martin to call the extorting victim right now and stated that he would go out there and kill that nigga. Defendant Martin then connected defendant Henley with the extortion victim and participated in the extortionate call. Defense response. At best, this is a civil dispute over payment for work done on a vehicle. The hyperbolic language, kill that nigga, is common vernacular in this cultural context and does not constitute a threat. The government must prove the statement was intended and understood as a genuine threat of imminent violence, not frustrating venting. Again, these inflammatory and prejudicial calls offer speculative probative values and will result in a waste of time in defending against unrelated acts that are not connected to the charged offense. Skylar is killing me. Let me pause this. So, At best, this civil dispute over payment for work done on a vehicle, the hyperbolic language, kill that nigga. It's common vernacular in this cultural context and does not constitute a true threat. See Virginia versus Black, 538 U.S. 343. This Supreme Court, they cited the Supreme Court, 2003. The government must prove the statement was intended and understood as a genuine threat of imminent violence, not frustrated venting. Again, these inflammatory and prejudicial calls offer speculative probative values and will result in a waste of time in defending against unrelated facts that are not connected to the charged offense. Overt Act number 148, Exhibit C28 through C29. On November 14, 2022, on an intercepted call, Defendant Henley described to a former NFL player that Defendant Henley would beat the shit out of the producer who owned of the studio in Las Vegas because he started shit between Defendant Henley and Whack 100. When we go live, I'm gonna make sure I bring the video, which is going to tell you what he said. The wiretap, which also says that Big U told Molly Mall to cut Whack 100 off because he's a federal informant. Molly Mall tried to start some shit and ran back and told Whack 100, man, he on to you, man. He told me you was an informant. Well, Molly Mall is also an informant, allegedly. You know what I'm saying? So, yeah, man. Now, here it goes. Now, let's hear what the defense response is to that. Again, this is an attempt to distract the jury with a mention of famous NFL players. Further, this is a private conversation expressing personal frustration, not a threat communicated to the producer, not a demand for money, and not an act in furtherance of any charged scheme. There is no evidence that the producer was ever contacted, threatened, or harmed. As such, this is just another unnecessary distraction. Overt Act number 149, Exhibit C30 to C31. On November 22nd, 2022, on an intercepted call, Defendant Henley told an incarcerated individual that anyone coming at him better come correct because Defendant Henley always has two blowers, i.e. firearms on him. He could be bluffing. The man wears sweats every day. Where he got the two blowers? I mean, come on, man. But anyway, so he got two blowers on him in sweats. Ain't that a bitch? But anyway, defense response. At best, the statement was made to an incarcerated person in a private conversation, not to any victim, not in furtherance of any robbery or extortion. It is street-level bravado, not a criminal act. The government has not identified any victim who heard this statement or was placed in fear by it. Mere possession of firearms, if true, is a separate matter not charged any count in the indictment. As such, this is just another distraction from the evidence in the case. Overt Act number 150, Exhibit C30 to C31. On November 22nd, 2022, on an intercepted call, Defendant Henley told an incarcerated individual that Defendant Henley was going to charge someone in federal prison $6,000 to have a phone smuggled to him. Defense response. This allegation is entirely unrelated to the charge RICO enterprises alleged purposes of extortion, robbery, murder, or fraud. There is no identified victim and no evidence this ever occurred. The government is padding the overt act list with uncharged, unsubstantiated conduct to inflate the appearance of a criminal enterprise. As such, this cause should be excluded. Good argument. Overt Act number 151, Exhibit C35. on November 23rd, 2022, on an intercepted call, defendant Henley said that he can pay 3 people $50 each to beat someone up. Defense response: this government does not identify who Henley was speaking to, who the target was, or whether any assault ever occurred. A hypothetical statement about what one can do is not an overt act in furtherance of a conspiracy. This is speculation, not evidence of a completed or attempted criminal act. Great argument. Overt act number 152, Exhibit C34 to C35. On November 23rd, 2022, on an intercepted call, defendant Henley described paying people to mess up a store that was refusing to provide defendant Henley a discount. Defense response: no victim is identified, no store is named, no assault is alleged to have occurred, and no payment is documented. This is an unverified, unsubstantiated statement with no corroboration. No corroboration. This one gotta be out of here. This is a great argument. The reason they always, for conspiracy RICOs, need corroborating evidence is to get it admissible into the court. And whether it's the superpowers of a RICO, whether it's a conspiracy, or whether it's a continual criminal enterprise, CCE, you cannot erase his constitutional right to a fair trial. This speculative evidence that has not been corroborated with 20,000 wiretaps, 4-year investigation, should not be admitted before the jurors. Overt Act number 153, Exhibit C36 to C37. On December 27, 2022, on an intercepted call, defendant Henley told a Big U Enterprise associate that they need to hang OG Crip. They need to hang OG Crip, cuz. Defense response: the government has not identified OG Crip, cuz, has not alleged an assault occurred, and has not established that his statement was understood as a directive to commit violence. Overt Act number 154, Exhibit C38 to C39. On December 27, 2022, on an intercepted call, defendant Henley told another Big U Enterprise associate that OG Crip cuz needed to be disciplined thoroughly for a violation of cripping. Defense response: the government has not alleged that any physical act of discipline occurred, identified the victim, or established that this statement resulted in any harm. The government is attempting to criminalize speech about internal community norms without proving any criminal act followed. That's a fact. Overt Act number 155, Exhibit C40 to C41. On December 30th, 2022, on an intercepted call, defendant Henley said that when defendant Henley catches whack 100, I'ma break his jaw. The defense response: this is a private statement of frustration, not a threat communicated to whack 100. There is no evidence whack 100 ever heard this statement, was placed in fear, or was harmed. The government has not charged any assault on whack 100. So, on top of that, when did FBI begin investigating Big U for RICO? So this was December 2022. Big U was already on Whack 100 helmet at that time, cut him off and wasn't fucking with him. The murder of RW was January 2021. So you're basically saying a year and a half. So we don't know how long. Okay, I was just checking that out. So there was no evidence Whack 100 ever heard this statement, was placed in fear, or was harmed. The government has not charged any assault on Whack 100. Overt Act number 156, Exhibit C42 to C43. On December 31st, 2022, on an intercepted call, Defendant Henley said that Defendant Henley was bigger than the deceased rapper Nipsey Hussle, that Defendant Henley disciplined Nipsey Hussle, and that Defendant Henley was bigger than any other Rolling 60. Defense response: this is a statement of personal status and reputation, not a criminal act. Nipsey Hussle is deceased and cannot be a victim. The government is using this statement to inflame the jury with the name of a beloved public figure. Facts. The statement does not allege any specific criminal act and is inadmissible character evidence under Federal Rules of Evidence 404B without a proper limiting purpose. Overt Act number 157, Exhibit C4 to C45. On December 31st, 2022, on an intercepted call, Defendant Henley said that if anyone has an issue with Defendant Henley, they will no longer be alive. Defense response: this is a private statement made in a private conversation, not communicated to any identified victim. The government has not identified who Henley was speaking to, who the statement was directed at, or whether anyone was placed in fear. Hyperbolic or hyperbolic statements of self-defense or dominance made in private do not constitute criminal threats. Yeah, that's a fact, bro. That you see what kind of prejudicial evidence they're trying to introduce to the trial jury so they could get him convicted by prejudicial evidence and not the actual crime. If they had case was so strong, why would they need to try to prejudice them with these other things, right? Overt Act number 158, Exhibit C46 to C47. On January 1st, 2023, on an intercepted call, Defendant Henley said that he was not beefing with Nipsey Hussle, because if anyone beefs with Defendant Henley, I'm going to kill him, period. I am going to murder him. So, mind you, Nipsey Hussle's already dead. So he's saying, I wasn't beefing with him. If it was beef, I'm going to kill somebody because I'm fearing for my life. Anyway, defense response. This statement was allegedly made on January 1st, 2023, nearly 2 years after Nipsey Hussle's death in 2019. At best, Mr. Henley is speaking in the past tense about a deceased individual. The statement is not directed at any living victim, was not communicated to any victim, and cannot constitute a true threat. The government is using this statement to inflame the jury and to bootstrap the RW murder allegation through innuendo. That's a fact. Overt Act number 159, Exhibit C48 to C49. On January 2nd, 2023, on an intercepted call, Defendant Henley told BigU Enterprise associate DS that to manipulate the press for DS's lawsuit against law enforcement, DS should show both positive and negative parts of his life, wear glasses, and say that he was working with developing options, even though he was not. Defense response. This is an attempt to introduce the jury to an unrelated lawsuit, not obstruction of justice, not witness tampering, and not a RICO predicate act. Advising someone on how to present themselves favorably in a civil lawsuit is not a crime. The government has not charged Henley with obstruction in connection with DS's lawsuit. Overt Act number 160, Exhibit C50 and C51 on January 2nd, 2023. On an intercepted call, defendant Henley told BigU Enterprise associate DS that defendant Henley needed to at least break the producer's jaw. Now, I could see BigU clowning. Man, I gotta at least break the nigga jaw, man. Come on, M. But he's clowning, bro. I can't let him get away with that, and we laugh about it. But he's not even tripping off this dude, right? Defense response. This statement was allegedly made in a private conversation with DS, not communicated to the producer. There is no evidence the producer was ever contacted, threatened, or harmed in connection with this statement. The government has not charged any assault on the producer. At best, this is frustrating venting and not a criminal act. Overt Act number 161, Exhibit C52, C53. On January 3rd, 2023, on an intercepted call, defendant Henley described to an incarcerated individual tooling up with firearms to travel to a Crips neighborhood because we are the most arrogant, bougie, self-righteous motherfuckers on planet Earth, right? Defense response. No victim is identified, no assault is alleged, and no specific criminal act is described. At best, the statement is a boastful expression, not an overt act in furtherance of any charged scheme. The government has not alleged and cannot establish that Mr. Henley traveled to any neighborhood, possessed any firearm, or committed any act of violence in connection with this statement, because if he did, he would be charged with it. So this is not relevant conduct. Overt Act number 162, Exhibit C54 to C55. On January 3rd, 2023, on an intercepted call, defendant Henley told an incarcerated individual that defendant Henley was going to purchase 6 miniature phones to send to the incarcerated individual so that he could sell them in prison for $1,000 each. I wonder who that was. Defense response. This allegation is entirely unrelated to the charge RICO, predicates of extortion, robbery, murder, or fraud. There is no evidence this ever occurred, no identified prison, and no identified buyer. The government is again padding the overt act list with uncharged, unsubstantiated conduct that has no nexus to the charged enterprise's alleged criminal purposes. Overt Act number 163, Exhibit C56 to C57. On January 5th, 2023, on an intercepted call, defendant Henley said that another individual was done for being a rat. Defense response. The government has not identified who Mr. Henley was speaking about or what action, if any, followed. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. Overt Act number 164, Exhibit C58 to C59. On January 12, 2023, on an intercepted call, defendant Henley said he wanted to beat the shit out of WAC 100. Defense response. The government has not identified what action, if any, followed, because none did. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or a RICO predicate act. The defendant must prove a specific criminal act, not a cultural attitude. So we're talking about a private conversation. Is not tampering with a witness because Big U wants to beat the shit out of Whack 100. So if any action followed, no action followed. Big U never got to fade up or get in the gloves with Whack 100 and beat the shit out of him. You can set up a fight. I'm quite sure y'all seen Blueface just have a fight that was set up by Whack 100 in the gloves. We also got the pay-per-view, which legalized having a fight and beating the shit out of someone, right? However he had to do it, he wanted that fame. But the government, but Big U's lawyers is saying, expressing disapproval of an informant in private conversations is not obstruction of justice. They talking about Whack 100. Whack 100 CS2 back. In the same line, Big U's attorneys just let the rat out of the bag. They got the rat in the rat trap by identifying, talking about an informant. Well, who are they talking about? Defendant Henley said he wanted to beat the shit out of Whack 100. So expressing disapproval of an informant in private conversation is not obstruction of justice. It is not witness tampering, or it is not a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. I don't fuck with rats. Y'all can't charge me or introduce this statement that I said, fuck that nigga. I want to beat Charleston White ass. Didn't say I'm going to beat his ass. I want the fade. We could get in the ring with the gloves on or UFC match, whichever state would make it legally lawful. Why is this information about this alleged informant? Well, I'm going to say he didn't say alleged informant. He said an informant. Why is me speaking in private about this informant relevant to this case? See, my boy Byron Blake was off, but like I said, that doesn't exclude Whack 100 and his fingerprints all over this case. It doesn't exclude Big U's lawyer referring to Big U talking about an informant as it pertains directly to a statement about Whack 100 not being obstruction of justice or witness tampering or a RICO predicate act. This is nasty work. Overt act. Matter of fact, clip that. You know what I'm saying? We finna read that one more time. Clip that. Right? Overt act number 164. Let's blow this up big. On January 12, 2023, on an intercepted call, defendant Henley said he wanted to beat the shit out of Whack 100. Defense response: the government has not identified what action, if any, followed because none did. Expressing disapproval of an informant in a private conversation is not obstruction of justice, witness tampering, or a RICO predicate act. The government must prove a specific criminal act, not a cultural attitude. Clip that. Rat. Big U lawyer listed him as a rat that was being talked about, an informant being talked about in private. It ain't against the law to dislike rats. to not approve of rats, disapprove of an informant? This is not a RICO predicate act. Click that. WAC 100 is being labeled as an informant by Big U's attorney in the court file. That rat going down on the wrong side of history, nigga. You not just a rat, you's a marsupial. Now documented in another case that you weren't a victim or charged in. Nasty work. Overt Act number 165. Exhibit C60 to C61. On January 17, 2023, on an intercepted call, defendant Henley discussed traveling to Jordan Downs within Grape Street Crip territory and threatening to kill motherfuckers every day until he got his things back. Defense response. Again, the government has not identified what property was taken, who took it, whether Mr. Henley traveled to Jordan Downs, or whether any threat was ever communicated to any person there. A private statement about what one intends to do is not an overt act without evidence of follow-through. Facts. An overt act number 166, exhibit C6 Duse to C63. On January 17, 2023, on an intercepted call, defendant Henley stated that he was the hunter of the 60s and that he had obtained paperwork on individuals that should not be associated with the gang anymore. Hey, man, I got work on niggas that shouldn't even be out here. Them niggas being bad. Defense response. Again, the government has not alleged that any identified individual was threatened or harmed as a result of this statement. Overt Act number 167. Exhibit C26. On February 13, 2023, on an intercepted call, defendant Henley told a co-conspirator that defendant Henley was going to break the jaw of the business manager for a former NBA MVP. Damn. Defense response. No assault is alleged to have occurred. The statement was not alleged to have been communicated to the business manager. This is another private statement of frustration with no follow-through. All of these dudes, he said he was going to break their jaw, and he ain't broke nobody's jaw. So what's up with this Big U enterprise? Hold on, before we keep reading. How are you alleging this is a Big U enterprise and that when he gives orders, he's the head, when he gives orders or says something, so do it or else? But he wants all these dudes' jaws broke and wants to knock them out, and none of them being knocked out. None of them jaws being broke. None of them being killed. That don't sound like an enterprise to me, bro. Respectfully. So these overt acts shouldn't even be admitted, because he obviously doesn't have the capabilities to carry out his wishes. Overt Act number 168 on February 14, 2023. On an intercepted call, defendant Henley described smacking the Jew boy again. Defense response. The government has not identified Jew boy, has not charged any assault, and has not produced any medical records, witness statements, or corroborating evidence of any physical altercation. The use of the slur is inflammatory and prejudicial. The statement, even if credited, described a past act, not a predicate RICO act. But when you say I slapped him, it doesn't mean, smacked him, it doesn't mean you actually slapped him, bro. Nigga, I just smacked Vegas for 1,500, nigga. For real? What was on your ticket? Nigga, I took the Lakers. I took the over, and I took Denver. I smacked them niggas. That's Ebonics, bro. Doesn't mean that he literally smacked them with a motherfucking his hand. They could have had a bet on a game. These people crazy, bro. Overt Act number 169, Exhibit C66 to C67 on April 1st, 2023. On an intercepted call, Defendant Henley asked someone to grab Defendant Henley's blower, which he left on the ground in a blue sweatshirt in front of a tire. Defense responds, the government has not established that a firearm was actually present, that it was retrieved, or that Mr. Henley possessed it. Mr. Henley is not charged with a firearms offense in the FSI. This overt act and associated evidence is being used to suggest firearm possession without charging it or proving it, absent a direct nexus to a charged count. Generalized gun talk functions as propensity evidence. Because he possessed or talked about firearms, he is the sort of person who would commit extortion, robbery, and murder. Facts. Rule 404B prohibits that reasoning, and Rule 403 independently bars the evidence. Overt Act number 170, Exhibit C68 and C69. On April 23rd, 2023, on an intercepted call, Defendant Henley discussed gang politics with a co-conspirator and stated, I'm retired, nigga. I'm retired, nigga. Activist. I'll pull up on your block right now, nigga, and show up and show out, nigga. That's what happened to the last niggas that thought I was retired. You know what I'm saying? Hey, listen, bro, niggas talk that shit. Talk that talk. Niggas go stand. Just because I'm retired don't get me fucked up. I come out of retirement and pull up on that block, show up and show out. That don't mean he was actually finna do that. He could be bluffing. This is the concrete jungle. Those left without jobs, those left without hope. Sometimes bluffing can be your only weapon. And this is some of the language that lawyers need to properly understand to defend Eugene Henley Jr., a.k.a. Big U, a.k.a. Hannibal, a.k.a. Draws. Defense response. The government is using Henley's words to paint a character portrait, not to prove a specific criminal act. The phrase, that's what happened to the last niggas, is ambiguous and does not constitute an admission to any charged offense. This is precisely the kind of propensity evidence FRE 404B and 403 are designed to exclude. 4. The June 15, 2022 arrest of defendant Robinson and the ghost gun found in Robinson's vehicle, Exhibit D1 to D3. As discussed above, general firearms evidence is among the most prejudicial evidence the government can introduce, especially where firearms are used to imply dangerous character rather than prove a charged act. This arrest does not appear to be connected in any way to the charged offenses. Mr. Robinson is not charged anywhere in the FSI with the possession or usage of firearms. Any potential testimony to that effect will be uncorroborated testimony by a cooperating witness, unsupported by any other witness or physical evidence. Notably, none of the voluminous exhibits offered by the government in support of their specious extortion allegations involve any mention of firearms in any capacity by Mr. Robinson. The alleged possession that triggered the arrest in 2022 is the constructive possession that comes with the control and operation of a motor vehicle. Mr. Robinson was not found with a weapon on his person, nor was the weapon linked to any sort of criminal activity alleged against Mr. Robinson or anyone else. The isolated instance of a single arrest for a single act of constructive possession does not help the government to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence, or mistake, or lack of accident for any of the charges in this case as they relate to Mr. Robinson or any other defendant. Additionally, Mr. Robinson's separate arrest should be excluded entirely as to Mr. Henley. It is not proof of Mr. Henley's knowledge, intent, or modus operandi. It is proof only that someone else allegedly possessed a firearm on another occasion. That is classic spillover prejudice. Facts. Recorded conversations in which Mr. Henley allegedly discussed the enterprise's use of rolling 60 members. Let me close this door. Maybe Maria here and the baby going crazy. And that echoes through the house, and she's still going crazy. Let's finish this up. Recorded conversations in which Mr. Henley allegedly discussed the enterprise's use of rolling 60 members, including overt acts 116 and 156, Exhibit E1 and to E7. The court should preclude any evidence at trial relating to the rolling 60s or Crips because these gangs are not the charges RICO enterprise. Such evidence can cause jurors to convict based on fear, stereotype, or moral disapproval rather than evidence of the charged conduct. Here, the government seeks to use references to rolling 60 members to imply access to violence and criminal manpower. Unless the government can show that a particular statement is necessary to prove a specific charged act, this evidence should be excluded. Now, here go Maria. Hold on. I told y'all. So, that should be excluded. The Nipsey Hussle management dispute. They trying to say it was a dispute because of his management, basically saying that's his modus operandi business, right? The alleged diss song, the claim that Nipsey had to be disciplined, and the assertion that the dispute with RW unfolded in a similar fashion. Exhibit F1 to F39. This is the most prejudicial shit that the government has tried in this whole case, right? Trying to tie Nipsey Hussle, which they agree. Big U, they found no evidence through their investigations that Big U was connected to, had anything to do with, or the Big U enterprise, right? So if that's the fact, then why are you constantly trying to use Big U? Well, Big U had something in common with Nipsey Hussle. They fell out before, and Big U felt that Nipsey had to be disciplined. It went bad, but they made back up, which really goes against their theory that RW's diss song was on it, but that's just prejudicial, right? On a murder charge. This nasty work. No eyewitness, no murder weapon, and a weak-ass motive to kill him. Oh, he killed them because he made a diss song. So did Nipsey. And Nipsey didn't have to be killed. Nipsey was a bigger artist. That's kind of counterproductive to your whole argument. But in any event, where's the diss song anyway? Then you admit that Big U might not even heard the diss song. But let's get back to it. As discussed above, this is one of the most prejudicial categories in this notice. I just said that, right? It is precisely the sort of prior bad act analogy that Rule 404B forbids. Because the government claims Mr. Henley previously had a similar dispute with another artist, the jury should infer he likely acted similarly with RW. Mr. Henley was never charged with murdering Nipsey Hussle. In fact, another person, Eric Holder, was charged and convicted for the murder. Further, the facts presented at the trial in that case strongly supports the proposition that the shooting of Nipsey Hussle arose from a personal and immediate confrontation with Mr. Holder, not from any suggestion that Hussle had disrespected Big U. by terminating him as a manager or releasing a diss song. The prejudice is enormous. The celebrity reference will magnify the emotional and reputational impact on the jury. And the phrase had to be disciplined is inflammatory, ambiguous, and likely hearsay laden. The court should exclude the category in full, prohibiting the government or any witness from mentioning Nipsey Hussle. Evidence that Celebrity Socks received $6,000 in SBA funds despite allegedly having no income. Exhibit G1 to G3. This category is classic forbidden propensity evidence. The government seeks to argue that because a different entity allegedly received a small SBA payment under suspicious circumstances. Mr. Henley must have acted with fraudulent intent as to other charged financial transactions. That is an impermissible chain of reasoning unless the government can show close similarity, temporal proximity, reliable proof, and a genuine disputed issue. The amount at issue is modest. The asserted similarity is thin, and the danger of prejudice and confusion is high. The court should exclude this evidence. Agreed again. Intercepted calls and surveillance concerning alleged efforts by Mr. Henley and defendant Martin to use violence or threats to recover recording equipment belonging to Lil Wayne and NBA Youngboy, Exhibit H1 and H16. While the government did provide a list of 30 intercepted calls that relate to this alleged conduct, no surveillance reports, videos, recordings, photos, or any other items of the sort were disclosed. What the calls indicate are that after NBA Youngboy and Lil Wayne had recorded equipment stolen, someone affiliated with them allegedly called Mr. Henley seeking help recovering them and offered to pay $20,000 for the said recovery. Salute, click that. NBA Youngboy, Lil Wayne had a problem. Who do they call? The most influential, just person in the community of Los Angeles that they knew. Man, they stole our music equipment, bro. I don't know who it was, or I do know who it was. Can you just, bro, I'm not trying to send nobody to jail. I just want my shit back. Bro, this is what we do to make our money. Man, I'll pay you $20,000 if you could be successful in doing that. So Big U, being an advocate of the community, of the Crenshaw district, of Los Angeles, why would we want to run off young brothers who got resources, the bag, influence that could help inspire these kids to do something bigger? I'm mad now. I'm taking it personal. So forgive me for taking it personal that somebody in our community is going to prey on black men who have become successful, who are pillars in the hip-hop community, and who are assets and earners that can help change the narrative between in these YNs in the neighborhood. There's not a YN in hip-hop today with more influence on YNs than NBA Youngboy. And you come to LA and somebody steals what you do and takes away from you, I got a problem with that. I'm going to get you your equipment, but I need to have a talk with these dudes and be prepared for whatever come with it that they stole your equipment. Because we don't want to discourage successful people from running from our community, feeling threatened in our community. We want to invite them, make them feel comfortable so that they can feel comfortable interacting with these YNs and get them a positive message. Show them that there is other things they could do besides rob, besides sell dope, besides gangbang. Clip that. This is the type of testimony that every one of you niggas in the Crenshaw district who kids play football, who made it successfully and graduated from Crenshaw, that y'all seen with Big U do in his community, protecting his community, protecting black people from being preyed on, need to contact Big U's attorney. We just told you his name at the beginning, and let them know you guys want to testify on character as far, and this is a challenge as a character witness to Big U doing this exact thing. Where was the police? You see why we don't call the police in our community? How would you think the police was going to really try to get them back, get back their stuff? No. Well, Big U volunteered. But anyway, the person who called Henley indicated that they were tracking the stolen items via a GPS tracking device and provided Mr. Henley with updated location information. Mr. Henley then called Mr. Martin to see if they knew anyone in that neighborhood who could help them intervene and recover the stolen items. After Mr. Henley reached the suspected location of the thieves, he left because it seemed that someone associated with Lil Wayne and NBA Youngboy had gotten law enforcement involved with the recovery of the stolen items, and law enforcement was present at the suspected location of thieves. This is not congruent to any other alleged conduct. Mr. Martin's participation is tenuous at best, in that he tried to help think of resources in that particular neighborhood where the stolen items were believed to be located who could help recover the said items. As for Mr. Henley, the government is yet again attempting to backdoor evidence that he possessed a gun and that this means that he is a violent person. Further, this category should be excluded because it invites precisely the sort of celebrity-driven contamination that Rule 403 is designed to prevent. The government seeks to transform an alleged dispute over property into proof of violent criminal disposition, enterprise methods, and access to celebrities. Unless the government can show that this incident is charged or directly proves a disputed element of a charged offense, the evidence is collateral and unduly prejudicial. 9. Witness 2's anticipated testimony concerning A, his 2016 or 2017 donation for helmets, B, the statement regarding Nipsey Hussle, and C, witness 2's allowing Mr. Henley's artist to record for free because he felt he could not say no. You felt you couldn't say no? I thought y'all was brothers. Ain't that what Loose Cannon said on No Jumper? I thought y'all was all brothers. How could you not be able to tell your brother no? I asked Booger for some money. He might give it to me. He might say no. But that's my brother. So you got to be able to accept a person's yeses the same way you accept their no's. If that's your brother. These alleged acts are remote, prejudicial, and weakly connected to any charged offense. A donation from 2016 or 2017 is outside the core timeline of the charged conduct and risk confusing the jury with stale collateral matters. The statement about Nipsey Hussle's are ambiguous, hearsay laden, and likely to be understood as strong-arm character evidence. Witnesses 2's subjective feeling that he cannot say no is not proof of an actual threat or extortionate demand, especially where no evidence exists that Mr. Henley was aware of witnesses 2's fear. The court should exclude the category in full. That's a fact. 10. Donor 1's anticipated testimony concerning A, his donation as an alleged donor victim, B, an attempt to clear a gambling debt, and C, the allegation that Mr. Henley recovered fraudulent gambling winnings for NBA players. Exhibit J1. Man, they trying to make Big U sound like Robin Hood. You know what I'm saying? They trying to make him sound like Robin Hood. But in the reverse. He's not stealing from the rich. He's going to retrieve from the crooks, from the criminals, intervene to get right or wrong because he has relationships. He's leveraging his relationships over decades to do good on behalf of people who were wrong. And they're trying to twist that into some kind of criminal behavior because he's strong, because he's independent. They don't like those type of black figures surviving in our community. They only want lambs, sheep, those who have no resistance, no structure, no leadership qualities, unless they're puppets of the government. This is clip that, man. This category is highly prejudicial. The government conceived that donor one's donation lies outside the statute of limitation for any substantive charge, yet seeks to use it to portray Mr. Henley as a fraudulent operator. This additional references to gambling debt and recovered winnings are even more problematic. They are vague, uncharged, and likely to trigger a celebrity-driven mini-trial. This evidence should be excluded under Rules 401, 403, and 404B. 11. Additional sex-related intercepted communications, including November 28, 2022, and January 7th and 19th, 2023 calls, and alleged January 7th, 2023 payment discussion, and the February 8th, 2023 massage company with happy endings call. Exhibit K1 to K16. The government's notice indicates that it intends to stretch the boundaries of Count 19 and taint the entire trial with character evidence regarding Mr. Henley's sex life. The government cannot use generalized sexually explicit or morally charged communications as stand-ins for proof of the charged transportation count. Crude sexual talk, discussions about women, pricing, or even commercial sex do not by themselves establish transportation and interstate commerce with the requisite intent. This material is highly inflammatory and risks conviction based on moral disgust rather than proof of statutory elements. The court should require the government to connect each communication to the charged element, offense element by element. Otherwise, that category should be excluded under Rules 403 and 404B. 12. Alleged consciousness of guilt evidence, Exhibit L1 to L10. This category should be excluded. Flight evidence is probative of a defendant's guilt if four inferences are justified. 1, from the defendant's behavior to flight. 2, from flight to consciousness of guilt. 3, from consciousness of guilt to consciousness of guilt concerning the crime charge. 4, and from consciousness of guilt concerning the crime charge to actual guilt of the crime charge. United States versus King, that's a 9th Circuit 1999, and U.S. versus Silverman, 9th Circuit 1988. Here, the consciousness of guilt evidence offered by the government is inherently weak because the inference chain is fragile. Fear, travel, silence, phone inactivity, and even abrupt movement can be explained by a number of innocent or non-inculpatory reasons. The government's effort to pile together unrelated conduct, travel, device usage pattern, and prior stories about fleeing law enforcement only magnifies the danger of unfair prejudice. Most troubling, the government expressly seeks to introduce prior statements about earlier flights from law enforcement, including jumping from a window and discarding firearms. If the defense contests the government's characterization of current events, that is textbook propensity reasoning. Because he allegedly fled before, he likely fled now from consciousness of guilt. Rule 404B forbids it, and Rule 403 independently bars it. Conclusion, for the above reasons, the court should exclude each of the 12 categories of inadmissible evidence and hold the government to its burden of proof. Listen, man, Maria ain't here yet, so I'm going to stop sharing, and I'm going to give y'all a bonus. You know what I'm saying? It's already 2 hours and 20 minutes. I'll give y'all a bonus when I go live with it. Let me get this out to y'all at 6:30, man. Damu Kiwe. Hit that like button. Hype me up. Also, the Cash App at $ Active Chucks. Y'all can hit me on that. I need the money. I need the money. So, all right. Today, we're not even talking about the government yet. We're focusing on Big U legal team only. Because what they filed, let me break it down like this. Hold on. So what they filed is not just a motion. It's a strategy to shrink the entire case. What this motion is trying to do, let's keep it real and simple. Big U lawyers are asking the judge, do not let the government bring in all this extra stuff, specifically prior acts, rumors, public, personal, celebrity situations, old conversations, social media, alleged unrelated conduct. Why? Because they're saying this will turn the trial into a circus. The core legal weapon, Rule 404B, the entire motion is built on one powerful rule. You cannot convict someone just because they seem like a bad person. That's Rule 404B. And Big U lawyers are basically saying the government is trying to do exactly that. They argue this evidence is propensity evidence. It's designed to make the jury think he's this type of guy, so he must be guilty. That's illegal in court. Their main argument in this plain English, here's their message boiled down. Stick to the charges, prove the case, not the reputation. They're accusing the government of overloading the case with 12 categories of extra evidence, trying to trigger outrage, confusion, emotional bias. And they say, this isn't proof. This is storytelling. They attack the government's notice. Now, this is where it gets strategic. They say the government didn't even properly explain why the evidence is admissible under the law. The government has to identify the purpose, show a clear chain of logic, avoid any he's a bad person reasoning. But the defense says they just listed categories. No real explanation. That's a technical but powerful attack. The inextricably intertwined argument, now this is a big one. The government usually says all this stuff is connected to the case, but Big U's lawyers push back hard. That doctrine is abused, vague, and overused. They're basically telling the judge, don't let them use this loophole to sneak in everything, which is clear they're trying to do. They break down specific types of evidence. They go category by category, but the themes stay the same. Check in evidence. Defense says, this is branding, not a crime. Media clips, podcast references, public talk, they argue. You're turning into proof and extortion. Public statements and interviews, they argue. You can't use what someone said publicly to prove criminal conduct without context. Plus hearsay issues, confrontation clause concerns, fear and control category. This is where they go hard. They say this is way too vague. You need specific acts. No victims, no fear, connections. They want this. This will create many trials in every allegation. Intercepted call strategy. Now, this is important. They take individual calls and argue. This is not extortion. This is normal talk. Business disputes or venting. Examples highlight. Shut this down. Ambiguous. He messed with the wrong guy. Just talk. I'll kill him. They're reframing everything as non-criminal interpretation. Celebrity and high-profile references. They attack this heavily. They say mentioning NBA players, Nipsey, etc., is designed to bias the jury, not prove anything, just create spectacles. Their Rule 403 argument is real powerful also. This is where the motion gets strong. They argue, even if the evidence is relevant, it should still be excluded because it's too prejudicial. It confuses the jury, it wastes time, leads to emotional decisions, and they quote the core idea. Jurors may overweigh bad character and deny a fair trial. That's classic Supreme Court language. Segment 8, what they're really trying to do, this motion is not random. It's a strategic repositioning of the case. They're trying to turn this from a Big RICO enterprise story into a narrow, fact-only trial, where the jury only sees specific charges, specific acts, nothing extra. Segments of their strength of their argument. Let's be real. They did some things very well. Attack vagueness, emphasize jury prejudice, highlight many trial danger, challenge government's lack of specificity, reframe language as non-criminal. That's strong lawyering. Now, the weaknesses of the argument, but here's the problem. They're acting like this is a normal case, and it's not. It's RICO. And when the RICO, the government gets to show the big picture. They get these superpowers, exclude everything not charged. That's where they kind of lose ground. So here's the real takeaway. BigU lawyers are trying to control the narrative and limit the damage and keep the jury focused on the facts of the case. And honestly, they're not trying to win everything. They're trying to cut down the government's bias. Not eliminate it, but to cut down the prejudice, right? Because they're obviously trying to get all of this in with the superpowers of the RICO. They make no hidden question whether or not they want to prejudice the jurors. But I think BigU's lawyers should have questioned the judge. The BigU, if the court, why should the court give inference to the prosecution when the burden of proof is based on them, when they feel it's necessary to prejudice the jurors with all of this unnecessary information, unrelated to the charges at hand? See, they want to convict him on his persona. They want to convict him on his past. They want to convict him on his former gang time. They want to convict him because of celebrities. And the bedrock principle of the Constitution guarantees a fair trial. And none of that will be fair. BigU is up against it because the federal government empowers these AUSAs with superpower. And a lot of these judges don't always side with what's right, especially against Black defendants. Let's pray for BigU. Let's pray for BigU family and his loved ones. And let's pray for the judge and his loved ones, and pray that the Lord instill this judge in this judge's heart to keep justice in mind and give BigU the fair trial that every U.S. citizen in this country truly deserves. I'm Duse M, the Don, and this is the Damu Kiwe Conversation. Yeah.